Hey everyone, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. This is the Facebook page called Foreclosure Help 777. Guys, if you want to join us, we talk about foreclosure related things. We share our cases with each other and help each other. And so today we're going to talk about a couple of things. A case update for some of us. I know y'all have been following the cases for the Winslows and Marlon Lewis, so let's take a look at the Winslows case real quick. If you Google Winslow, you can get the Pacer Monitor here, Winslow versus OCNBC, which you can see here. There's the case number 124CV03302. You can see the last thing that was filed was docket 62, which was an answer to the amended complaint. And you can see right before that, the judge issued an order accepting the magistrate judge's recommendation and ordered that certain counts were dismissed, except for one, which was the most important, which was the quiet title action. So his quiet title action gets to move forward. And now he gets to go through discovery. Isn't that wonderful for him? So, if you look at his docket altogether, you can see right here, here's the same thing. You can see at the very top the name of the judge and the presiding judge and the referring judge, which is the magistrate judge. And one of the things you guys need to know is this: magistrate judges are not who you want presiding over your case. You want the main judge to do it. And we'll talk about why. Let's talk about Marlon's case, which is a different situation altogether. Marlon's case, if you look it up in Pacer, is right here. Oh, that's his other case. His case is 424CV02727. It's in Houston. And if you look at his docket history, you will see that it started July 23rd, 2024. His home was sold in a foreclosure sale in July 2nd, 2024. Just to give you an idea, they tried to get him evicted. They haven't succeeded, and they're not gonna. So let's take a look at some of this stuff here. In his case history, you'll see that he filed an amended complaint, which was accepted. And then the other side filed their opposition, and he filed the other side filed an amended answer. And then they go and file a motion to dismiss right in the middle of discovery. And basically, the scheduling order stated that discovery had to be completed by sometime in July, which it wasn't, because they wouldn't give him discovery. I mean, they answered questions without answering it, and he couldn't file a motion to compel because he was past that time. And this pending motion to dismiss is still there, as you can see right there on number 264425, motion to dismiss for failure to state a claim. And he opposed that motion, as you can see right there, memorandum to defendant's motion to dismiss. So he actually opposed that motion to dismiss, but the judge never decided that. And so he never got his discovery. He's supposed to go to trial in November next month. And so what he's going to do is called a non-suit. And you can see the last thing here, it says motion for voluntary dismissal without prejudice. So he filed that in order to get rid of this case before they decided against him. Because, you get that feeling when a judge is not on your side. Well, guess what? He had that feeling. Judge wasn't on his side and was not. He was probably going to dismiss all his claims with prejudice and then never get to trial at all. By doing this motion for voluntary dismissal without prejudice, he preserves his claims and rights when he files his new complaint in state court, which he will do shortly. And so if we look at the voluntary dismissal here, you can see what it looks like. This is the cover page. It was filed yesterday. Plaintiff's motion for a voluntary dismissal without prejudice. Whoops, let's see what I did wrong here. And you can see it says, comes now plaintiff Marlon Lewis, appearing pro se, respectfully moves this court for an entry for an order of voluntary dismissal of this action without prejudice pursuant to the Federal Rules of Civil Procedure 41A2, and in support states, plaintiff no longer wishes to pursue this action in this court. No final judgment has been entered in this case. Dismissal will not prejudice defendants, and no party will suffer legal harm as a result of dismissal without prejudice. Plaintiff respectfully requests that the dismissal be without prejudice, with each party to bear its own costs and fees. And then the prayer. Wherefore, premises considered, plaintiff respectfully requests that the court enter an order granting this motion, dismissing this action without prejudice, and ordering each party to bear its own fees. And you can see on the next page is the proposed order, which you always want to put with one of these, so the judge can just basically sign off on it. Yay, yay, yay. And a certificate of service to the other side as well. Make sure they get a copy of this, which they did. So we'll see. I mean, I don't see why the judge wouldn't grant something like this. They almost always do, because they want to clear the docket. That's what they do. And so the next thing I wanted to go over with you guys is the difference between a magistrate judge and a regular federal judge. And I made this little presentation, why you should never consent to a magistrate judge. Okay? The magistrate judge trap. What a magistrate judge really is. They are appointed by district judges, not Article 3 judges, no lifetime tenure, limited to 8-year terms, handles pre-trial administrative matters unless all parties consent to full jurisdiction. Many homeowners don't realize that consent gives them power to enter final judgment. You don't want that. How consent happens. A notice or referral to or an ideal program notice arrives early. The form says you may consent to have a U.S. magistrate judge preside. Checking yes or failing to object equals permanent consent. You don't want that. Once granted, you'll lose the right to have an Article 3 district judge decide dispositive motions. Why this hurts foreclosure defendants. Magistrate judges handle hundreds of repetitive foreclosures and FDCPA cases. They often treat pro se filings as shotgun or frivolous. Their reports are almost always rubber stamped by the district judge. Consent equals you'll never even reach the district judge. The smart move, however, is do not consent ever. In a foreclosure, quiet title, or FDCPA case, file a 1-paragraph notice. Plaintiff does not consent to the exercise of jurisdiction by a United States magistrate judge under 28 U.S.C. 636C. Keep the case under Article 3 review for all dispositive rulings and final judgment. Okay, so you got to remember too that homeowners fail to check that consent box. And by doing that, or they check the wrong box, then they get the magistrate judge. So just remember this. Magistrate judges almost always recommend dismissal or summary judgment for the bank, and the district judge almost always signs off on it. How the trap works. The case gets referred early, either through the ideal program or general orders or an IFP in form of papyrus filing. The homeowner receives a form that says something like, you may consent to have a U.S. magistrate judge preside over your case. Thinking it's routine or faster, the homeowner signs it or doesn't return it at all. Some districts treat silence as consent. Once that happens, the magistrate becomes the trial judge, not just a recommender. At that point, it's almost impossible to get back to a district judge unless you file a formal motion to withdraw under consent, which is rarely granted. The correct move, always, do one of the following when notice of referral appears on the docket: filing a notice of non-consent to magistrate judge, or simply right at the top of your next filing. Plaintiff does not consent to the exercise of jurisdiction by a United States magistrate judge under 28 U.S.C. 636C. That single sentence preserves your right to have all dispositive rulings and final judgment handled by an Article 3 judge. Okay, let's talk quickly about Marlon's situation, why he filed a non-suit. Using a non-suit strategically in foreclosure defense. A non-suit is a voluntary dismissal filed by the plaintiff in state court or a pro se defendant who has asserted counterclaims. It is governed by, and in his case, the Texas Rule of Civil Procedure, or Federal Rule of Civil Procedure 41A. It allows a party to withdraw their own claims before trial without prejudice, meaning they can refile later. why Marlon's suit was smart, or non-suit was smart. Marlon filed his non-suit before the court ruled on pending motion to dismiss. That single move stopped the judge from issuing a dismissal with prejudice, erasing the pending deadlines like the pretrial order, preserving all his claims so they can be refiled cleanly, and removed the case from the federal docket before judgment. In short, it was a reset button before the system could shut the door on him permanently. Now, when should you use a non-suit? When should anyone use a non-suit? If a federal court looks ready to dismiss it under Rule 12b-6, discovery was blocked or delayed unfairly, you need to regroup and fix a pleading or evidence, you want to move the case back to state court where you have stronger jurisdictional control. Do not use it if you've already gone to trial or received a final judgment. By then it's too late. Anyway. And you can't use it if you're trying to dismiss someone else's claim. It only applies to your own. What happens after filing it? Once filed, the judge loses jurisdiction over your claims immediately, except to award costs. The other side's pending motions, like a motion to dismiss, become moot. You can refile the case in state court using improved pleadings and exhibits starting fresh. So this is what Marlon's doing. He's going to file a brand new file. He's not doing a TRO, he's doing a petition instead, just so you know. And we'll get to that on our next episode probably. So, hope this was helpful to you guys. Let's go back to the main page here. If you guys have questions, you can always send me an email to foreclosurehelp777@gmail.com, and I will try to answer your questions, or you can leave them in the comment section below. And as always, everyone have a blessed day.